Hey guys, Erik Kaiser with Probate Cafe, and we're on another episode. And today I have with me is Josh Ramirez, who is an estate planning attorney and trust litigation attorney. Right, Josh?
Right. Thank you. Yeah, thank you for having me, Erik. Yes. So the name of my firm is California Estate Planning Services. As Erik said, I do trust litigation, estate planning, and probate. Done this for about 10 years, and this is the only thing I've ever done.
Now, explain a little bit about probate itself, like if you can.
Yeah. So probate essentially is the process in which your assets go to the next generation. It's when you don't have a will, a trust, or even if you have a will, which we'll get into, the court system will pass your assets to the next generation. And that's essentially what probate is.
Oh, okay. And when is it needed?
Great question. So probate is primarily needed in a couple situations. The first and most common scenario is when you have real estate. When you have real estate and you pass away without any documents in place, probate happens. And the biggest downside is the court has a plan for you. The government already has a will in place for you.
That's what they say. If you don't have a plan, the state's got one for you, right?
Exactly right. Exactly.
And so I guess the people would want to avoid probate based on pretty much, based on costs or whatever they're paying to the state, right? Because do they have to pay the state out of probate?
Yeah, great question. And one big misconception with probate actually is the government takes it. The government takes something. And that's actually largely a myth. It is rooted in some reality, but largely a myth. The real big cons of probate, one of them is cost. It is extremely expensive compared to setting up documents with someone like myself. It is very lengthy and time consuming. It takes about 1.5 years on average, depending on which county we're in. And it takes a lot of time for the family, generally a child. A lot of time looking for paperwork and bank accounts and various things. Probate's also very public. For example, a trust, we can do whatever we'd like privately, which we'll talk about what a trust is. And the public doesn't know anything. But if something goes through probate, the entire world knows your affairs. The court system in America is public record, which is why we know certain things about celebrities who pass away.
Oh, yeah.
Yeah.
Interesting. Wow. Yeah. So the information, it discloses kind of their net worth, right? When they're passing or when they passed, because, right, you have the real estate that it discloses, but also has personal property.
Absolutely.
Right? And that could be what, bank account money?
It could be bank accounts. It could be the jewelry, family heirlooms, maybe things somebody didn't want the public to know or the government.
Yeah. Wow. Okay.
Yeah.
Okay. Yeah. So very public. So yeah, if you're a private person, you definitely want to set up a trust.
Absolutely, you do.
Wow. And it takes about 1 year to go through that process, typically, right? Because you have to go through court and do those things.
Absolutely, yeah. About 1 year. The longest that I've been a part of has been about 2 years. And of course, if there's some infighting in the family, it can drag out for 5-6 years. I've seen.
Wow.
Yeah.
So if there's multiple beneficiaries, which typically there are, there's always someone that either wants their money sooner, doesn't think the other person is doing a good job, or is not acting fast enough, and they're always. I find that maybe 5% of the time, I guess, that they kind of jump in there and kind of muddle things up a little bit, right?
Right.
And
right.
It just extends everything.
Right. In most families, there typically seems to be one child or heir that steps up and is the next leader of the family, or patriarch or matriarch. But unfortunately, in probate, it also calls out a lot of the family maybe we haven't seen in a while. What people say, people coming out of the woodwork, absolutely happens in probate.
Yeah, and it's interesting. I've been through those situations where if they don't think one particular person, the administrator or executor, is doing a good job, then they'll either try to step in or give the advice and what they should or shouldn't do, and it just becomes a nightmare. And then you've got to settle all that, and I think that's just something that if you can avoid it at all costs, that's huge. And then speaking of cost, again, probate is pretty expensive, right? Because there's statutory fees. Am I correct?
Yeah. So that's a great question. How do attorneys get paid, and how much does it cost, and does the government take anything? So probate is the way attorneys charge on probate is what are called statutory fees. That means the law tells us how much we can charge. So every attorney in the state of California would charge you the same amount of money. Those statutory fees are a percentage based on the value of the probate. An example, an $800,000 probate, a typical home in Southern California, would cost about $19,000 in attorney's fees. So the myth that the government takes, it's actually that the attorneys charge a lot. And so people get the idea that this was just expensive, but it really was the attorney. It's a large attorney's fees.
Sure, yeah.
There's actually one very large negative about probate, which is where the myth that the government takes your assets is rooted in. And that's if the deceased person was ever on Medi-Cal in their entire life. In probate, you have to tell the government, the Department of Healthcare Services, that the person passed. And if the Department of Healthcare Services say that the estate owes money, that could be a six-figure bill.
Wow.
And that's when the government does get their money back.
Interesting. So yeah, and then if they're in a situation, obviously there's beneficiaries. So if there's no, for example, trust involved, then basically they're probably going to sell that asset, so they can't really give it away or transfer it with the will. Usually the real property has to be sold, so there's another cost, right?
Another cost there, and after factoring in commissions and capital gains and the Medi-Cal recovery, that program is called Medi-Cal Estate Recovery. Sometimes there's not equity left. Sometimes the estate might be underwater.
Yeah. It's interesting. I find obviously certain demographics as far as the property values, typically everything is under $1 million that I sell. And
Right.
It's usually the people that don't want to spend just a little bit to protect themselves, and they end up losing a lot. And I actually did some numbers, and I thought it was more like 8 to 10% of the cost to liquidate the estate property, and working with an attorney. It's a huge amount of money. And so share with us how someone can avoid probate.
Yeah, and you're absolutely right, Eric. The huge amount of money there. So how someone can avoid probate, the number one and most common thing we do is trusts. You're driving down the freeway and you see those billboards all the time, revocable living trust. That's the way to avoid probate. And what a trust really is it's just a stack of papers, just a document. And it tells us who's in charge of your worldly affairs and who gets everything when you pass away. Pretty straightforward document.
Oh, okay.
Yeah.
Interesting. Yeah, I know. I've seen a few certifications. Is that the small condensed version that someone may need at a later time? And then you've got the big stack of all the stuff, the details. Right?
Yeah, and every lawyer is different. A trust size doesn't necessarily always matter, but a trust could be 5 pages. Technically, it could be on the back of a napkin if you really wanted to. Probably will end up in court on that one.
Yeah.
But a typical trust generally is about 50 to 100 pages, and it takes a lot to say who's in charge and who gets what. There's a lot more nuances. We talk about the taxes and who's paying for maintenance and lots of things in a trust.
Oh, okay. And share a little bit about, obviously, when we're dealing with probated property, I guess, real property specifically, during the probate, that period of whatever it is, 12 months that it's going to take. So share with us a little bit about selling the real property. For example, can it be sold, with different legalities as far as full, limited authority, that kind of thing, maybe some things like that.
Yeah, absolutely. So timing is one of the biggest challenges with selling real estate and probate. When we file a petition, it might take a few days sometimes it takes 3 months to finally see a judge and get somebody appointed in charge of the estate. That position comes by different names depending on whether you had a will or not. That position is most commonly referred to as an executor. We also call it personal representative or an administrator. Once we get somebody appointed in a few months, generally around 3, then they might have the ability to sell real estate. It all depends on whether your lawyer got you what is called full authority or limited authority. And limited authority is essentially where we have to go ask a court for permission on most actions, mainly to sell the property. And the biggest downside of limited authority, I've seen it all the time, is since we have to ask the court's permission for our sale price, you'll likely lose a buyer or several buyers. Think about it this way. If you're going and buying a house, you and your family, and the seller says, you're the buyer, but can you give us a few months while we wait for court and make sure this is okay? You might start looking at the next house. So that's the big downside, losing buyers, and all of a sudden investors might come in and you might get a much lower value. With full authority, which we can easily ask the court for, it also depends on the executor's background, their criminal background, and their credit score. But if we can get you full authority, then we can sell property without the court's permission. Ideally, we would always get full authority or go a fiduciary route.
Oh, good. Okay. Yeah, it makes sense. I mean, there's a lot of headaches with limited authority. And, once you go through that a few times and have to go through the court process, and I would not recommend that at all because, when you're selling real property to investors or anyone else with limited authority, there's a lot of things that happen. And I was just in a recent situation where we had a court date for April 10th, and which was a Monday, and I got a text message actually Easter morning about transferring basically the owners' names into two separate LLCs with holding title separately in separate percentages from the original one that we submitted the petition on. And just because they found out that there were some issues that would possibly cause an IRS audit buying the property in the name of the original LLC. Oh. So you run into those, and then you just got to go through this whole process again. And so that's where we're at. And it's because it just becomes a nightmare, and it's definitely something you want to avoid. So I think, and there's a lot of people out there that just try to do the paperwork themselves, right? I see a lot of people on the list, what do they call, pro per?
Yeah, pro per, actually. And you bring up a great implied point there that through probate, it takes away a lot of planning opportunities for families. We can't do things like LLC planning or save property tax or do a lot of neat strategies when we're stuck in probate. When I'm in court, I often am sitting there, last couple of years on Zoom, but I'm often sitting there and seeing people trying to do it themselves. You absolutely can. I have seen people successfully go through the court system themselves. And in fact, Orange County has a great self-help service for probate department. But what I also see is that a person doing it themselves, which is called pro per, does take a lot longer than necessary. I couldn't tell you how long they take because I'm obviously not their lawyer, but I do see a lot of continuances. They're in front of a judge, and the judge says, something's wrong, I'll see you in a few months. And sometimes it's the wisest decision is just to hire the lawyer and let the lawyer take care of the probate.
I think that is a wise decision.
Yeah.
I've learned as I've gotten older that you want to hire the professionals that specifically do what they do.
Right.
Yeah, especially with this market, it's still a seller's market in my opinion. But with rates adjusting, you just don't know where you're going to be at in 2 years, and it could be a huge issue, and it costs you a lot of money. So it's almost like you're better off spending a little bit now instead of losing a lot later.
Right.
So I think that you hire the people that know what they're doing, and just things cost money. It is what it is. You can get anything cheap usually, but cheap usually isn't good, right? And it's not to say that it's extremely expensive, but it could be more expensive doing it yourself and having all these other things that no one really can see, and understanding that, whether it's dealing with the property, trying to sell it yourself as a pro per, and not really understanding how to work with investors, what to look out for, because their strategies are always to tie you up in escrow and renegotiate. That's their basic one. That's the typical one. Wear you down, extend everything out, and just cause you a lot of stress. And typically I work with probably 20 plus estates a year selling probate and trust properties, and you run into it a lot where I try to take on that stress, because you don't want the client to have that stress, because then they start making the decisions just to make them, and they could lose money for all the beneficiaries, whether it's 5, 10, 15,000, it all adds up.
Right.
And that's something that I run into quite often Which leads me to my next question is, what does someone need to think about, when they're going to sell a property, right? It's in probate, I guess, and they need to sell it. What should they be thinking about?
Right. So the biggest thing in my mind, outside of the typical when should you sell real estate, the timing and who you should sell it to, is who is selling your real estate. And now, I'm not trying to suck up being on your show today, Erik, but believe me when I say having a probate specialist realtor sell your real estate when you're in probate matters. Having someone with your credentials, for example, matters. I've worked with a lot of realtors who have never been involved in the probate system. And as I need paperwork for the court and I need to do my job, when the realtor is just a realtor and has no experience with this, it harms us. And I could say fairly confidently that it does depreciate the value of the house. I think clients can get more money when they hire someone that has the specialty.
Yeah, and there's certain. It's interesting. There's a lot of people in that niche market where they'll take a course and this and that, and but I always try to explain to clients or potential clients, always do someone's review of kind of what they've done as far as what properties they've sold, maybe who they've worked with as far as other attorneys. That helps. I mean, everybody starts somewhere, but to know, every situation is different as well. Is it going to be really tough? Is it going to be a complete renovation? Then, okay, well, who are you using? Do you get discounts for these subcontractors, right? Your flooring, carpeting guy, are you going to get discounts on that because you use them a lot? And make sure how many, if not, then you probably want to get a few different estimates because you really want to know your numbers, because that's where you can lose a lot of money. If a renovation, something that you can do maybe for $30,000, and then somebody else that doesn't have that experience and they're just kind of hiring, a contractor here or there, you're gonna pay a lot more because the relationship isn't set up. So you could end up paying maybe $50,000. So that's kind of the difference of what I see out there.
Right. One thing I see quite often is families always know a realtor in the family. Typically, it might be one of the child or an in-law. And the downside, there's lots of downsides. Of course, I will start with the good. And of course, the thing that families try to do is say, we're going to have a family member sell because we're going to save money on commission. What I will tell you is, most of the time, that's what's said in the beginning of the probate. By the time the sale happens, I usually see commissions on the escrow statement anyways. So using the family member really didn't work to save money. The other potential things to consider, and not all families will be like this, but is it a conflict of interest if by having a family member sell? You have a fiduciary duty as an executor or administrator of an estate to get the best and highest value, to do construction right, to follow the law, maximize value, and oftentimes taking little shortcuts to save a buck here or there harms us in the end.
Oh, for sure. Yeah. I see that a lot. And a lot of times agents that specialize, they're not there yet with that experience level, so they won't have insurances to cover them. For example, if you're doing work on an HOA, something happens, you want to have, the agent should have their own commercial liability and personal liability insurance as well to back them up in their decisions that they make. And you'll find that agents will say, oh yeah, I'm insured. It's insurance, errors and omissions, which has nothing to do with what they're doing for the client. And you talk to probably 95% of the agents out there that specialize in probate, when they're doing these renovations, they won't have it. Most of the subcontractors will have their insurance. Hopefully, that's kind of what you're trusting them to have, or get them to provide it beforehand. Typically, is what you do. But the agent should still have their insurance just in case there's something that happens. Somebody backs into a wall in an HOA complex or something like that, damages stucco, it's a few thousand. So, typically, we solve those problems even if they did happen. But if it's something major, you don't know. Plus, if something happens, if the property's left open by a subcontractor and somebody goes in and squats and just lights the place on fire, I mean, there's all sorts of things that can happen that people have no clue of because they haven't been through that process. Right. So it's kind of interesting. The more times you go through it, the more you learn. Right.
There's definitely more to it than let's change the locks and put a sign out front. Much more to the story.
And then you've got to factor in the negotiation aspect of selling it, right? So I I'm in escrow on a property that I sold in San Diego County, and I think we've had 15 offers, and the estate didn't want to do any renovation to the property, so it's being sold as is. So we've got to develop our costs to see what it's going to take to renovate. We look at our after repair value and all that stuff. But just dealing with the people that try to just get the offer accepted, and then who they are, and managing all that, there's a lot of work involved that people don't really understand. They think you just put it on and sell it. But if, we've got to be accountable to the estate, right? I've got to tell them, okay. And one thing that I typically do is I'll set up a GoPro at the open house, so I can actually show. A lot of my clients are out of the area, so I can show a time lapse video. These are the number of people we had through. These are the investors we had through. So I can say, okay, well, we had this many eyes on the property that actually viewed it. We have this many offers. So you got to communicate all that stuff so people know that you did your job in doing that. You just don't send them an offer. Oh, I think we should do this one. You've got to kind of walk them through that process, so everybody knows what's going on. And if anybody has questions, like another beneficiary, if they go back to the client, usually they're not really going to understand how to communicate that. So a lot of times I'll do video, market reviews, and things like that, so it's really clear, right. So they don't run into those issues about, well, why did you do this or why didn't you do that?
That's you made a couple great points there. I can't tell you how many times so my job, I'll start with, my job is to always advise people to take the highest and best value. That doesn't necessarily mean the highest dollar amount. Generally it does, but not necessarily. And so when I ask realtors, let me see all the offers so I can guide the client with the realtor, and we're all making a team decision, I can't tell you how many times I just get a couple of numbers. Here's the offer and here's the number without any other information. Are they pre-qualified? Are they all cash? How many people were at the open house? So things that you're doing will really help the lawyer do their job much better. The other thing you mentioned about insurance, very good for realtors to have insurance. And hopefully not too many attorneys are listening, but please make sure your attorney has malpractice insurance. I can tell you numerous horror stories where people came to me and nothing they can do about the past mistakes because attorneys did not have malpractice insurance. So make sure your probate attorney does have malpractice insurance, and ask them how much. We, as attorneys, can have a pretty low amount, shockingly low amount. So make sure they have enough to cover whatever we're dealing with, enough to cover the house in case something goes wrong. $1 million, $2 million. For example, our firm has $2 million coverage. And I think that's sufficient to guide clients.
So here's a question. What would you say is the best way to avoid probate? Is that formulating a trust, creating a trust, or?
I definitely would say that is the number one best way, is to create a trust. Every family is different, so that I'll call generic advice. Every client who would talk to me, I would say most do end up setting up trusts. But there are multiple ways to avoid probate, and every family might have a preferred strategy. Another example is having a joint owner on something. That could be a bank account or a house. Well, when somebody passes, that asset goes to the joint owner. So we don't have to go through probate. That's just done internally, usually through the banks. That can be great with certain family dynamics, but most of the time that's actually not my advice. Adding your child to a bank account is a pretty bad idea. For many reasons why you can imagine. Your child could steal from you. Your child could accidentally take assets from you and use the wrong debit card. Your child could get in a car wreck, and now those assets are part of their creditor claim. So we really don't want to have your child be added on your bank accounts. One of the most common questions I get about setting up trusts and avoiding probate is, well, why can't we just add my child to the property? And I will tell you, that is the simplest way to avoid probate, absolutely. Just doing a simple deed that you can get from Walmart. You can go get a deed. But there are severe tax implications with doing that. There's negative capital gains tax consequences. That's the biggest. And what that is when somebody buys an asset, that is what is called your basis. As that asset appreciates in value and one day you go to sell it, that difference, that is what is called your capital gain. That usually gets taxed at around 30%, roughly. So when somebody inherits property, that basis jumps up to the fair market value on the date of death. That's called a step up in basis or an adjusted basis. Well, if you add a child on your asset, they don't get that adjusted basis on your death. That's a gift from the government for inheriting. They actually get your basis. So you might save a lot of money. You don't need lawyers. Just go to Walmart, get a deed, add your child, and we're good to go. But one day when your child goes to sell, they're going to kick themselves for not doing it the right way, because they'll have a big capital gains tax built in, almost always 6 figures. That could have been avoided if we just did a trust.
And if there's other beneficiaries, other kids, they're going to want that property to be sold, or it's harder to refinance it and everything, because it isn't the person that wants to keep it. Then now they have to qualify for that additional amount and pay that tax.
Absolutely, Eric. The strategies that I was mentioning are great for families with one child, very close-knit family. It might be something we discuss. But when there's a family with multiple children, these strategies generally go out the window. You don't want multiple children on one bank account, for example, with you. Now we don't know who to blame if something goes wrong, more creditor issues, lots of problems. With a house, we don't want to add multiple kids on your property. All the tax consequences are still there, all the negatives. There's actually an additional negative tax consequence with Prop 19 and property tax, which we'll talk about. And the biggest downside is now your 2 children or multiple children will be property owners together. And it might sound good for mom and dad, usually not good from the sibling perspective. We usually don't want to be owners with somebody. It's our sibling, a stranger.
Yeah.
So that ends up in court a lot, forcing a sale.
Wow. Okay.
Yeah.
So, share a little bit about the fees involved in setting up a trust. In relation to obviously to the expense of not having it. What can someone look forward to as far as what they need to invest in protecting themselves?
Absolutely. So when we say the word estate plan, that it means several documents usually. Generally, it means creating a plan for your estate, of course. But when we create a book of documents, that consists of things like a trust, a will, power of attorney, some healthcare documents, everything you're going to need for your aging and end of life. That kind of plan typically ranges between $2,000 and $3,000 for a family that is relatively simple in one house. Of course, costs can change. Some people like to decide to, I call it control from the grave, and put a lot of restrictions on their children and grandchildren's inheritance. Or there might be some special needs beneficiaries we have to plan for. Or really worried about creditor protection from the daughter-in-law you might not like, or son-in-law you might not like. So all of those things, of course, can make trusts and estate plans more complicated and i.e. more costly. But at its root, about $2,000 to $3,000, which compared to an $800,000 probate at $19,000 seems to be a no-brainer.
Even more than that, right? Because even if they're probably going to sell a real property anyway, if they don't have that set up, or they may not have to.
Right.
If they're not set up before that all happens. I see that's really common. Where they could have just taken these steps before that, and they could have done it right and just been prepared. Worst case, something happens. Because sometimes half the time you don't know what's going to happen. Or more than half the time, something. Why not be prepared for it, right?
Absolutely right. We know it's going to happen. It's not if we're going to pass.
Yeah, it's when
we're going to pass.
It's when. So you might as well
plan for it.
Yeah,
it's going to happen. So let's plan for it. And when we plan, we don't have to sit around the room and cry for days and days and days about it. We can plan and move on with our life and live life and enjoy your children and grandchildren. One thing, as you were speaking, Eric, you mentioned we were talking about fees. I didn't mention that probate has more fees than just what are called statutory attorney's fees. So one fee that they can charge this executor is the executor's fees, and they get paid the identical amount that I get paid. So on that $19,000 probate example I was giving, all of a sudden $36,000 is gone from the estate. 19 to me and 19 to the administrator. That administrator is generally one of the children that usually was closest to mom and dad. And you can believe that siblings aren't too happy when one of their siblings got paid more, and they view it as more of an inheritance. Because siblings don't see the job, because it is a job being an administrator.
There's a lot of work
A
involved.
lot of work. And the other fee is what's called extraordinary fees. So you should always talk to your lawyer about this right up front. Extraordinary fees are fees that the lawyer, me, can charge above and beyond those set statutory fees for anything that was considered out of the ordinary. For example, if you and I are talking about selling somebody's property and we're talking for hours and hours on the phone, I could charge extraordinary fees for that. Now, our firm typically doesn't, but lots of firms make a lot of money charging those extraordinary fees.
And you don't see that until the end, right?
Yeah, you don't see that until the end. So if you have a probate, or you're going through a probate now, or you have a probate attorney, ask about the extraordinary fees and don't get blindsided.
Yeah, that's really, and then you factor in, if they're going to sell the property, right? You get real estate fees and all of that going into it.
Yeah.
It could be pushed up, 80,000 or so, maybe more.
Pretty high.
And if you're a beneficiary, listen to this, or you're a potential future beneficiary, right? If you're a distant, if you live far away from, your parents possibly, but your other siblings are really close to your parents, they live locally, then, and if there's no trust set up, there's could be some issues. And if you're a beneficiary, I definitely recommend pushing to do the planning. Just because you're not local doesn't mean you can't push for that planning. And I think that's important.
Absolutely. So as a child, one of the best things you can do is to encourage your parents to call a lawyer and set up an estate plan. Talk to their lawyer about a trust. Now, that encouragement comes with a very fine line. We can't force our parents to do anything, our aunts, our uncles, we can only suggest. If that ever happens and you are guiding your parent, please let your parents make all the decisions. They're going to speak to the lawyer. They're going to do all the planning. One of the big things I'm seeing a lot, almost every day, is undue influence claims in court. And they always started with, and because we ask these questions in depositions, they always start with, how did this estate plan come to be? How did the lawyer first even get contacted? And if you're a child calling lawyers and telling them what your parents want and emailing and doing all that, doesn't look so great. And most people have great intentions until there's the one person who doesn't have good intentions. So please encourage your parents to call their lawyer, but that's about it.
Interesting. Yeah. And so if somebody's going through the per process, right, with probate, and they're getting just bogged down, or they're having, the other beneficiaries contact them, hey, what's going on, that we want our money, what's taking so long? And if they have issues, they can always hire an attorney after, right? Like yourself. They can come to you and hire you, right?
Absolutely. Yeah. You don't need an attorney from the beginning. Of course, it is much more beneficial if we start right from scratch. But I have been contacted by several pro-per clients in my career, and I take over the probate. Sometimes it's in the beginning or the middle. Typically not at the very end. I'll usually just give some advice and guidance, which I'm always happy to do. But I'd be happy to talk to you if you're in a pro-per situation and you're just stuck, or you feel like your siblings are getting upset, or you just don't know where you're headed, or the court is telling you to do something and you don't know what they're telling you to do. Give me a call. Sometimes it might just be advice. Sometimes I will take on your probate for you.
And share with us, where can you assist someone? Is it just through the state of California? Is it nationally? Or explain a little bit about that.
Yeah. So right now we can assist you in California. We are licensed in other states, but for probate purposes, we practice in California. I have completed probates from San Diego up to Sacramento. Ideally, you would want a probate counsel somewhere around the area where you're going to file. So if you're in San Francisco, you should look for an attorney up in Northern California. However, we can practice anywhere. Most of the courts now are all virtual. I haven't set foot in a courtroom since before COVID.
Oh, wow.
Just going on Zoom and Microsoft Teams. And so we can handle probates anywhere.
Oh, okay.
But yeah, give me a call and we can just chat what makes sense for you and your family.
Yeah, and we'll put Josh's information in the link or somewhere that you can you can reach out to him and connect with him about that. And then I think one last thing I wanted to bring up, if you're in a situation and you actually have a trust and there's issues with family members either selling the property or any other issues that have stalled the process of liquidating, I guess, the trust assets. Josh, you also handle trust litigation, is that right?
Yes, I do. Now with trust litigation, there's kind of two sides. You might be an upset beneficiary trying to find out information, or you might be the trustee who's getting hammered with all sorts of questions and concerns. So if you're that trustee, we'll start there. Please give us a call. There are rules we have to follow, and they're very nuanced rules. They're found in the probate code. So even though you might have a trust, we are following the probate code, not to be confused with probate and not having any documents. So trust law is found in the probate code, and lots of requirements for a trustee. So if people are starting to ask questions, please call us, and you will always get honest, blunt advice from me. I will tell you what you've done right, more importantly, what you've done wrong, and how do we fix it. If you're an upset beneficiary or you're just trying to find out what's going on, the law has your back. The law tells us what you're entitled to, what information we can get, what trust we can see, what we can't see. So we have great success obtaining documents, whether that's bank statements or trusts, seeing if there were any changes. Generally, it's just finding out what's taking so long. And we can do that. We can talk to the trustee and their counsel and try to nudge this along.
Okay.
Yeah. A typical administration after somebody passes with a trust can range anywhere from about 4 months to about a year.
Okay.
So much shorter than a probate, and it can go very fast if the family is getting along well, can waive a lot of formal requirements. We can wrap up a trust inside of a month if we wanted to.
So here's another question, I guess, or I should say a statement that, I see a lot of times attorneys don't specialize, or you're working with an attorney that does, maybe criminal, family, divorce, and estate planning, as opposed to, going with someone that just does estate planning. Because what I see is, like, obviously, the fees are, can be quite beneficial for an attorney to some degree on a probate. So you'll see, a divorce attorney wanting to dip their toe into doing a probate, and that's kind of where I see is like, there might be some issues there, and they're not knowing, if you don't specialize, you're not going to have as much knowledge as someone like yourself who specializes only in estate planning and trusts and all of that and probate, rather than working with someone that may do, the divorces and or maybe small criminal matters. You got to wear all those hats. It's hard to be good at it, right?
Absolutely, it is. The probate code is very lengthy, very nuanced. It deals with probate and elder abuse and trust law, conservatorships, and all sorts of things. All of those practice areas go together. So when you see attorneys' websites like my own who say probate and elder abuse and Medi-Cal and trust litigation, that all makes sense. It's in one set of law.
Yeah.
When you see your probate lawyer doing probate and personal injury, that doesn't make sense. You see them doing probate and DUIs. That's ludicrous. You're absolutely right. A lot of attorneys think it's an easy way to make money. It's not. It's more than just filling out forms. A lot of attorneys also try to do estate planning and set up trusts and think it's just who gets what. It's just putting in a name. As you heard, we're talking about taxes and elder abuse and litigation and all sorts of law. Medi-Cal is very important for seniors in nursing homes. All sorts of laws all boil down into this trust and probate field. So yes, please make sure your attorney focuses in one area, or if the firm does multiple things, at least that attorney does trust mainly in probate. And you can always find out about it on their website. That's a good trick, is look at the law firm and look at their practice areas. And if it's all over the map, they are not focused.
Yeah, I've seen that too, because I'll get the list, and I'll be able to tell kind of who's doing a lot of the work. I can kind of recommend, someone like yourself is, you're versed in, handling a lot of probates a year, what you're doing, where someone else's that I see as far as their firm, they may not have that experience.
For having me, Erik. Thank you.
Thank you.